Welcome back to today's video, where we once again see Eric Martin, a self-proclaimed sovereign citizen, making another courtroom appearance, this time on a domestic violence charge. He's standing before Judge Slavin, who wastes no time shutting down Martin's off-the-wall arguments while adding a few sharp remarks of his own. Although the audio starts mid-conversation, it's immediately clear that this hearing is going to be an eventful one.
And I reserve all my rights before I cross this bar.
Sure. Let the record reflect that you are a living man, because dead men cannot speak. So, and I can hear you
It's fraudulent presumed anyways, though.
All right. So, this is people of the state of Michigan versus Eric and Martin. Today's date and time set for a pretrial in this matter. Are there any issues that need to be brought or raised before the court?
Excuse me if I may at first. Mr. Martin indicated he did not want me as his attorney, so I'm asking for permission to withdraw.
I had, first off, Mr. Martin, I had previously appointed Mr. Gazicki as your house counsel. Mr. Gazicki has made a statement that you do not want, and you have indicated to him that you do not wish for him to be your attorney. Is that correct?
Yes, and not just him, any attorney, because I will not be allowing attorney to turn me over to the court, the jurisdiction of the court, which is what they do. This is why I don't set them normally.
All right. So you want to represent yourself, is what you're saying?
Not represent myself, but present myself.
Present yourself, represent yourself, same thing, sir. Again, we're not going to play semantics like you did the other day.
Yep.
So
the law is based on
it's the same thing, sir. It's the same thing, literally the same thing. Look at the thesaurus, present, represent, sure. So the motion is granted. You can withdraw, sir, Mr. Gazicki, and Mr. Martin, you'll be presenting and or representing yourself in this matter. Because you have a constitutional right to do so, and you can. So, today's date and time set for a pretrial. So, Ms. Sobe, you have not had the opportunity nor chance to speak with Mr. Martin, who is improper. Is that correct?
That's correct, Judge.
All right, so I'll allow the two of you. I will set this case over, and I'll let
Judge,
you two discuss the matter in the hallway or in your office, and then I'll recall the case after you guys have had a chance to pretrial the matter.
Before we get into that, Judge,
Sure.
I do want to put on the record that my victim's advocate, Ms. Delisha, has been in contact with the complaining victim in this case at great length, and there is a no contact order. The victim is the brother of the defendant in this case, and he's notified us that he is still living in the same house. So the defendant and the victim are living in the same house, even though there's a no contact order. Further, the complaining witness has indicated to us that he's being threatened by the defendant in his own home, once again violating that no contact order.
Are you really surprised that someone facing multiple domestic violence charges, who already believes the law doesn't apply to him, would ignore a court order to stay away from the victim and even go as far as making new threats?
The complaining victim, to my knowledge, is in the hospital at this time. He's unable to zoom in, even though he wanted to be here.
He's in the check-in room right now.
He's been attempting to, but he is in the hospital, could not be here in person. He might have audio.
I think they're in the. I don't know what this thing is. I got Kurt Martin
Yes.
in the check-in room. So if you want to zoom back in, or you jump in back in on Zoom, Kurt Martin is in the check-in room right now.
Yes, the people just wanted to bring that to the court's attention, the multiple violations of the no contact order, the living in the house and the threatening and speaking to the complaining witness.
All right, so sir, are you still living in the same house with the victim?
I object to that question as violating my right against self-incrimination, so we'll not be answering that question based on that. And also I want to object to her what she just mentioned. First, I want to mention allegations that I'm there. That's not sufficient evidence that I actually am there. And number two,
I'll just have a bond hearing, is what I'm saying.
Well,
and then everybody will be sworn in and all that kind of stuff. Because I've already given you bond conditions. Part of those bond conditions was that there should be no contact with the victim. If you're living in the same house with the victim, you need to go somewhere else.
Well, first of all, he ain't a true victim. That's something I'm object to. First of all,
first off, listen, I'm not even going to entertain any of your stuff. This internet, Google the internet type stuff that isn't even real or true. All right, I've already ruled on most of your motions, and I'm going to let you rule. I'm going to let you bring your motions again, and I'm going to make rulings on them. But what I'm saying is you don't have a choice in the matter. I gave you bond conditions. They're alleging that you violated the bond conditions. So under the Constitution, I can't just say, oh, you're in violation. No, I need to have a bond violation hearing. And if you are in violation of my bond conditions, then I can hold you in contempt. If you're not, then you're not, and the case just goes forward. It's as simple as that. It's called due process. So what I'm saying is when she says when you say you object to the alleged violations that she's alleging, listen, you don't even get a chance to object to that. That's their job that's their job to bring those. And if they're correct, they're correct. If they're not correct, you have the right to have a bond hearing. And at that bond hearing, if it gets proven by a preponderance of the evidence that it is true that you violated my bond conditions, then I will proceed accordingly. And if not, then the case will just go forward and you'll still have all your constitutional rights. So what I'm saying is your objection is overruled because there is no objection that can be made to allegations because that's all they are is allegations.
So objection made based on the Constitution. There's no sufficient evidence that he lied.
You don't seem to understand. This is a bond hearing, not the time to argue. You're being told that a bond violation hearing is coming soon because you failed to follow the conditions, and that's where you can bring up all your pseudo-legal claims for the judge to dismiss.
Sure, you're testifying. You're not going to testify. You're not going to testify. Listen, you're not going to testify. If you want to testify at your bond violation hearing, you can do so, or you have the right to remain silent. And anything you say can and will be used against you. So what I'm saying is, the only reason I'm cutting you off because I don't want you to step on your own constitutional toes. Everything you're saying could be used against you. So I don't want you to say something that you didn't mean to say, and then all of a sudden, they get to use that against you because that's your right to remain silent. You understand that, right? You understand what I'm saying? Okay, I'll take your silence. I'll take your silence as an affirmative.
No.
So, well, you didn't say that you didn't understand. So,
no, I do not understand.
You don't understand.
I do not stand under anything you're saying. So, but anyways, this discussion for emotions
from an English standpoint. You're not standing under anything. I didn't build a bridge. I didn't build.
Legally, it's not all
I didn't
based on.
Put up an umbrella. I didn't put up a canopy. I didn't put up any kind of other item that you could stand under, a ladder, you name it. So there's nothing that I've said that you can stand under. But what I am saying is you do have the right to remain silent. And anything you say can and will be used against you at trial. So that being said, I'll let you go into the hallway. You can meet with Ms. Sobe and have a pretrial in this matter, and then we'll deal with after Kurt talks with the victim advocate, and then you talk with the victim advocate. We'll decide when we're going to have the violation of the bond condition hearing.
Thank you, Judge.
So I'll remind you, this case is scheduled for a motions hearing, and
So the two of you can go out and have your pretrial.
My demand.
I just told you go out and have hallway have pretrial. If you don't want to talk to her, then don't talk to her. That's up to you. But what I'm saying is right now.
I'll talk to five. I'm saying, but right now I have these.
Sure, you're not controlling these proceedings. I said right now is the time for you and Ms. Sobe to have a pretrial. If you're going to have a pretrial, we'll do that. I'll control when cases get called in front of my court. Thank you very much.
It's clear Judge Slavin has run out of patience with Eric Martin's antics. After a short pretrial conference with the prosecutor that went nowhere, Martin returns to the courtroom and immediately locks horns with the prosecutor over jurisdiction.
Dismiss the case for lack of jurisdiction is denied. 1, you live in Taylor. 2, you allegedly committed a crime in Taylor. 3, the complaint was filed here in Taylor and was sworn to here in Taylor. So under that Constitution, you availed yourself of the jurisdiction. You live in Taylor. You enjoy all the protections of the police department, the fire department, garbage services, you name it. You have more than adequate minimum contacts with the jurisdiction. And I find that your motion has no merit and is denied.
I object to that. As my argument, Article 3, Section 2 of the U.S. Constitution, that's totally irrelevant to when a state's a party. This court doesn't have original jurisdiction, or the U.S. Supreme Court has original jurisdiction on Article 3, Section 2, and Article 3, Section 2 doesn't allow them as reasons to deny or to say that you do have jurisdiction. They do not allow it.
Sure, Article 3, Section 2.
Your denial of my amendment.
Again, your motion is denied. Article 3, Section 2 of the United States Constitution deals with when one state sues another state. And that's like trash cases like New York versus New Jersey, things like that. But they have original jurisdiction over those cases. This is the state of Michigan versus an individual who lives here in Michigan. and that's you. And so, living man, living trust, living Stewie, whatever you want to call yourself, guy, big E, little G, I don't know, whatever, all that good stuff, big M. None of that makes any sense, nor does it make any difference legally. The fact that I have little yellow tassels around the flag over here, that doesn't change anything either. This is the United States. Sure, keep on mumbling. This is the United States. This is Taylor. You live in Taylor. You committed a crime allegedly in Taylor. So the case is going to start here in Taylor. And so that's why I have jurisdiction over you, for the reasons stated on the record. And just the obvious, the United States Constitution and Michigan Constitution, I have jurisdiction over this case. So that motion is denied.
As I mentioned, this isn't Judge Slavin's first time dealing with someone like this, and it certainly won't be the last. He knows the Constitution inside and out and has no trouble handling these kinds of baseless arguments.
With regard to bond conditions, your motion to stay or set aside or dismiss the bond conditions is denied. The Michigan court rules, which are set forth by the Michigan Supreme Court, are the ones who specifically state that I can set bond conditions in order to do a couple of things. One, to make sure that you appear at court. Two, to make sure that there's a difference between the parties or allegations of violence against the parties or between the parties, that I can keep the two parties separated in time. So you need to be not living in the same place as the victim in this matter. Now, at the bond hearing, I'm going to set a bond hearing for the alleged violations of that bond hearing, because one of the things I need to know is who owns the house, like legally owns the house. Because I'm a big proponent of property rights, and that was one of the biggest things that we moved over here and created a constitution, and why property rights, and you can't just take people's property and all that kind of good stuff. So somebody's going to be moving out in the meantime during the trial. I don't know if it's you or if it's a victim. Whoever actually owns, like owns the house. I'm not going to order somebody to move out of their own house and let a victim or alleged victim stay in a house that they don't even own. The victim will move. That's how that's going to work. So if you want to check with the victims and see who actually owns the house.
To my knowledge, I believe it is the mother's house,
Okay.
and they are brothers.
And the mother is still alive?
To my knowledge.
Okay.
Is she alive?
You talking about my sister, Lisa Martin? No, she always keeps saying she owns it. She don't own nothing.
Who owns the home?
Well,
I'll just look up the Wayne County Register of Deeds. Council, just make sure you just do a search in the Wayne County Register of Deeds, find out who owns the home.
Well, under adverse, non-adverse possession law, because I've been living there a minimum of 15 years under that state statute.
No, you see, again,
Listen.
listen. You just have no law, I literally teach it. So just telling you, you're wrong, because you can't have adverse possession with permission. If you have permissive use of the property, you'll never, ever going to get adverse possession.
Adverse or non-adverse, okay?
Okay, there is no non-adverse, trust me. I don't remember that one ever being on the bar exam. You know what? Hey, whatever bar exam you want to take, you let me know. I'll study for that one too, and I'll take that one.
I'm not so sure Eric law degree written in Cran Martin really wants to go head-to-head with Judge Slavin. Because when it comes to the law, the judge clearly knows his stuff, while Martin is still stuck playing games.
But to answer your question, let me finish saying, you always want to try to cut.
No, because I want to wait till everybody's under oath. I'm just saying, I'm staying at the hearing. I want to know legally who owns the property.
I was also mentioned, no, we can do that too. I'm just saying, but it's always.
Oh, we're not ready to do that now
Parents'
today.
Justin, it was always my parents, right? House, so to say, and I don't even think they really owned it because the mortgage wasn't paid off. So I don't think really no one totally owns
A
it.
mortgage is just a promise to pay money. It has nothing to do with actual ownership. Ownership and mortgage are two different things.
I think actually all of us at the house are possessors of law. My understanding of law is we're actually possessors because the bank really owns, because the mortgage was never paid off, from my understanding. But it was always, so to say, our parents' house. Like I said, I don't think they really owned it.
Sure, here's what I'm going to do. I'm just going to go ahead and sua sponte, look it up in the Wayne County Register of Deeds myself, because it's a matter of public knowledge. And then I'll take judicial notice of the fact who's the owner.
Well, like I said,
That's all I got to do.
adverse and non-adverse possession, MCL statute.
What we're going to do is we're going to have a hearing date, and that hearing date is going to be on the same date as the jury trial. So in the meantime,
I have a right to be there because I've been there minimum
didn't say
15 years.
I mean, you don't have a right to be there, so you don't own the
Sure.
property. You don't own the property.
Under that statute, I am.
You don't own the property. So you need to vacate the premises because that's where the victim lives. I told you no contact with the victim.
then that's an unlawful void order because it violates.
But it's not, because I
Because
just
without
said.
any evidence, you can't just say, I can't
Okay,
be at a
so,
house.
listen, sir, I'm gonna tell you one more time. I'm not gonna sit here and argue with you. If you keep arguing with me in court here, I'm gonna hold you in contempt, because you're just holding up everybody else who's ready to go and proceed with their cases, and you just keep bringing up the same thing that isn't anything at all to bring up. I've already agreed my ruling on your motion. I've denied your motion. I told you that you can't live in the same house with the victim on a domestic violence case, when I told you you have no contact with the victim. And if you don't own the house, now, if you own the house, like actually own the house, like show me the deed that shows that you are the Wayne County Register of Deeds, that you're the owner, I'll make the victim move. Why? Because I'm not gonna kick somebody out of their own house. I'll make somebody will move, but it ain't gonna be you then. But you don't own the house. Okay, so, you're gonna need to vacate the premises. You're gonna need to vacate the premises.
Okay, and I objected, like I said, it's not just a deed whether someone owns it. Under the statute in Michigan, it mentions.
First off, what statute? Cite the statute.
Okay, I don't have it right in here because I was going to raise, but I'm going to give you the statute. You already know me. I cite MCLs all, I no problem. So I'm going to give the MCL statute, but it deals with what's called non-adverse or adverse possession. Okay. So if you live, one of the basic elements, you lived at a house for 15 years, right? Remember, this is my parents' house, right? I've been there 30 something years. When you lived in a house that long, you are considered part owner of these, if, you know, so, and therefore a right to be living at that house.
No, living at a property for 15 years doesn't automatically give you ownership rights.